Try to get everybody released if possible. Just remind members to turn their mobile devices off as it interferes with the recording equipment. Then item 1 is apologies. We received an apology from Sammy Douglas. Any other apologies? Nope. Okay. Agenda item 2 is the draft minutes of the meeting held on the 25th of March. You'll find the draft minutes pages 5 to 10 of your folders. If you want to just glance over those and indicate if you're happy enough for me to sign them. Great. Everyone happy enough?
Yeah.
Okay. Agenda item 3 then, matters arising. Item 1, forward work programme for April. You'll find that pages 12 to 16 of your meeting folder. Just to remind you that the first Justice Seminar is next Thursday at 1:30 in room 115. The Lord Chief Justice is giving the keynote speech on innovation within the youth justice system, and the committee meeting will commence after the seminar at 3 p.m. 2 further seminars will take place before the summer recess on the 21st of May and the 18th of June. I think we're on a lunch before that next week as well. Keith sent an email out earlier on, so if members can ensure that they get back to Keith and let them know if they're available for that lunch as well. Further work programme covering May and June will include the briefings the committee has agreed to and will be circulated to the members in due course. Item 2 is a response from the Prison Service on the oral evidence provided to the committee on the 4th of March. Refer members to pages 3 to 5 of their table pack. Just to remind members, the Departmental Secretary of NIPSA, Brian Milford, wrote to the committee in March regarding the oral evidence provided by the Director General and the Prison Service senior officials at the meeting of the 4th of March in relation to questions on the ending of the issuing of security notices to non-prison grade staff. Mr Milford indicated that, contrary to the statements made by the Director General to the committee, no one from the Prison Service had been in touch with him on the matter before or since the meeting, and he had not received a response to letters he had written on the 25th of February and 2nd of March on the same issue. At the meeting on the 25th of March, the committee expressed concern and agreed to request an explanation from the Prison Service regarding the oral evidence provided. The response from the Department acknowledges that the statement by the DG to the committee that members of the senior team discussed the issue with Brian Milford from NIPSA was incorrect, and apologises for any misunderstanding that has arisen. The letter outlines that the Prison Service had held high-level discussions with the PSNI on the matter, but the meeting between the Director of HR and Brian Milford did not take place until the 25th of March due to leave commitments. The meeting discussed arrangements for disseminating security notices to staff and PSNI, has reviewed the current process and is to issue new guidance which will extend the remit group to whom information is cascaded. So if members are in agreement, we'll write to Mr Milford thanking him for drawing the matter to the attention of the committee and perhaps providing him a copy of the response from the department as well. So if members are happy enough for that, or if there are any further comments. Okay. Agenda item 4 then is our first briefing of the day. So if I can invite department officials to come to the table. They'll outline the results of the consultation on the criminal law and abortion in cases of lethal fetal abnormality and sexual crime and the Minister's proposed way forward. If members wish to turn pages 18 through to 308 of their meeting folders for all the relevant information. I welcome Karen Pearson and Amanda Patterson. Just remind you that the session is being recorded and will be published in due course. And whenever you're ready, if you want to make your opening comments, and we'll open up to questions afterwards.
Thank you very much. Thank you, Chair. We're here today to offer any further briefing the committee might find helpful on the responses to the public consultation on the criminal law on abortion. Committee members have a paper from the department. We're conscious it's a very big and long document, Chair, and it provides a brief overview of the results and the conclusions. And just to recap, the Minister published a consultation paper on the 8th of October last year, presenting proposals to adjust the law on abortion for lethal fetal abnormality. The consultation followed the then Health Minister's conclusion that the issue of abortion for cases of lethal fetal abnormality could not be addressed in guidelines, but could only be dealt with by a change to the criminal law. And the consultation paper also set out questions relating to abortion for sexual crime. The consultation period closed on the 17th of January, and since then we've been involved in preparing a summary of responses, which the committee now has in draft, and which we intend to publish later today. Chapter 1 of the paper provides a brief summary of the views expressed, and Chapter 8 outlines the policy development and proposals for legislative change. As indicated in the covering paper, the proposals at this stage are confined to fetal abnormality, the responses to the consultation did not allow for a clear policy position to be reached in respect of sexual crime, and we've dealt with that in Chapter 9 of the document. The covering paper sets out the scale of the responses to the consultation and details some of the major issues raised by those in favour of change and those against change. And we've provided figures at paragraph 3. The response was large and varied, and the Minister was very grateful to have such a wide-ranging engagement in the consultation. The content of the responses were very varied. However, we think we can draw out some themes, and if we can just summarise those for you, they're set out in paragraphs 5 and 6 of the covering paper. In very broad terms, we think the responses can be said to span a range of opinion falling into 5 broad categories, and these are those who are against a change in the law, the petitions and the various lobby campaigns, and over 500 of the individual responses fall into this group. Secondly, those who are prepared to offer qualified support for a change on lethal fetal abnormality, but only with judicial oversight and where there's no feticide involved. Thirdly, those who gave full support for a change on lethal fetal abnormality. A number of organisations, including a major proportion of the medical bodies, were in this group, albeit with different views on the best way to achieve the policy outcome. Fourthly, others offered support for a wider change and going further than the Minister's proposals, and that would include serious abnormality and cases of rape and incest. And finally, the fifth group, a number of responses, including some political parties, albeit not in the Assembly, would argue for something equivalent to the 1967 Act. The covering paper also goes on to outline the policy development process and notes the substantial body of evidence from medical practitioners and their professional bodies, which stated that women in these circumstances need to have an option to terminate the pregnancy for their own health and well-being. The concerns expressed by those who were opposed to change were also considered very carefully by the Minister, and we hope we've adequately summarised those in Chapter 8. The paper refers at paragraph 12 to the proposed legislative framework set out in Chapter 8 of the document. The Minister is proposing to bring forward a change to the law which would provide a statutory exception, in addition to the existing case law exceptions, to the criminal offence of abortion in the circumstances where a diagnosis has been made of fetal abnormality which is likely to prove fatal, and the continuance of the pregnancy would be likely to have a detrimental effect on the health and well-being of the woman. The proposal also requires that in relation to a diagnosis of that type, an assessment must be made by 2 suitably qualified medical practitioners that the condition is likely to cause death either before birth, during birth, or in an initial period after birth, and in the event of the child being born alive, there will be no medical treatment other than appropriate palliative care and nursing care which could be offered to treat the condition. The proposals would also bring forward a clause on conscientious objection. We're happy to leave it there, Chair, and take any questions, and we're inviting the committee to note the responses we've received. We're inviting the committee to note the policy development and proposed legislative framework in the document and the Minister's intention to publish the document later today. Thank you very much.
Okay, thank you. Just before opening up to other members, I have a couple of questions of my own. First of all, leaving aside the merits or otherwise of the policy proposals and just specifically talking about the consultation exercise, I note that the Minister in his correspondence to the committee said, and I quote, "The Minister is of the view that there is sufficient evidence to suggest the case has been established for a limited legislative change to the law and that there is substantial support to make such a change." But reading through the consultation response, it appears to me that if you collate together the individual written responses, the response from representative bodies, the letters and the petition signatories, it's about 99% of people who are opposed to any change. Now, again, leaving aside the merits or otherwise of the proposals, how can the Minister say that he has substantial support, or he believes that there's substantial support, if in the public consultation 99% of people didn't want any change?
Well, I think the Minister's taken, I think he says in the consultation document, he's taken the broadest view of the material he had in front of him. I don't think he was taking it to be how many people actually responded to this consultation. It was the totality of what was said to him in this, the public engagement that had been prior to the consultation around. I think Amnesty had a survey which would have shown high levels of support. So he was taking all this in the round, and that's his view, that there is support for this proposal.
I think if I could just add to that, although there were a substantial number of signatures to the petition that was involved, there were some 65 responses from very key interest representative groups, of which 47 of those were in support of some form of change to the law. And most of those groups were representative of a broad swathe of interested opinion, such as the medical bodies, the medical professional bodies, medical practitioners, the Royal College of Midwives, the Royal College of Nursing. So those responses created a large weight of evidence in support of some form of change. And I think that's one of the things the Minister was referring to.
I mean, I accept that the petitions, even if you take the petition signatories out, because I think there is an argument that some of those signatories may be from outside of Northern Ireland, and I accept that. But even when you take those out, you're still dealing with a high proportion. Around 89% of people are still, opposed to any change.
Well, if you look at it purely in terms of the response to the consultation, but in terms of the weight of the arguments and the substance of the arguments and the content of what was being put forward from the individual organisations who are representative of a wide range of opinion. We had a lot of responses from trade union organisations, for example, which were representative of a lot of individual opinions. The petitions, 23,000 signatures. We're not sure that they all came from Northern Ireland, but even if you do accept that they are all from Northern Ireland, it's still a very, very small percentage of the overall adult population of Northern Ireland. So that was also taken into account.
Yeah. But would you not expect in a consultation exercise, if people are particularly supportive of something, that they too would take the time to write in, even if it was a short response? No?
That's not what experience would show to me. That mostly where an issue is supportive of an issue, that is more likely to encourage them to respond rather than the other way round.
I just find that the language curious when he said substantial support. I mean, again, without any judgment on the proposals themselves, I do think it's clumsy language to say there's substantial support, particularly on the same line as some of the results. And the public will, I think, rightly look at a consultation and ask, well, what's the point of a public consultation if the results are 99% against and the Minister then claims that there's substantial support?
I don't think we would accept that it's 99%, given that the responses from the organisations also represent a huge number of people. All the GPs in Northern Ireland, the nurses, the midwives. If you want to look at it on that sort of a basis, but we weren't doing that, which is why I think in the consultation document we've set out the sort of responses in that way to show that it's not a matter of numbers. It wasn't a referendum on which way somebody voted. It was to do with what was being said and who said it and the content of the responses.
And it is a particularly difficult subject issue, I think, for politicians, for anybody out there. I know that I and many others have met with families who have been through this, and your heart breaks for them. And I know the Minister is trying to find a way of ensuring that families who are in those situations don't go through the distress that they have, and I would acknowledge that. I think it's also important that we listen to the professionals and the medical professionals and what they say. They know far more about these issues than we do. And I noted that the majority of evidence from medical practitioners and professional bodies stated that women in these circumstances need to have the option to terminate the pregnancy for their own health and well-being. I think the health and well-being of the mother is hugely important, and rightly so as well. Can I ask if in the view of the medical profession, they were saying to you that they needed legislation in order to have the arrangements that they wanted? So were they specifically saying to you, we want this legislative change, we want legislation in the statute books to give them cover or to give them certainty, or what was their response?
Yes, I think that would be a fair summary of what they were saying. They were looking for a method, a way of ensuring that they could offer what they thought was the compassionate and the best practice and best medical treatment for women in those circumstances. In terms of how that was done, I think they would probably take a step back from that, given that legislation is not for them to decide on. But they were very anxious that there should be clarity and that it would offer both them as medical professionals and women in these circumstances sufficient clarity to know when such an option was available to them.
And much the same as in the other side of the consultation in terms of the sexual crime from pregnancy, from rape or incest. And I think most people would acknowledge the difficulties there is in legislating for that because of proving a rape or different things like that. It is very difficult to legislate for that. In the fatal abnormality issue, was there any concerns coming from the medical profession who perhaps agree with where the Minister wants to get to, the destination, but perhaps take a different view on the route to get there? So was there any concerns that by legislating for this issue that there may be unintended consequences and it may actually cause them difficulties in some of the other procedures that they're carrying out on a routine basis?
No, I wouldn't say that came across at all. I certainly think that there was a degree of reference in the responses from the Royal Colleges and others that they still would require and would like to see guidance on the case law and how that should be operated. But that did not detract from looking to legislate in a statutory way for this particular exception.
And I noticed in the oral question time in the House before the Easter recess that the Health Minister had indicated in response to a question that he was going to be bringing forward new guidance to the Executive within a matter of weeks, I think it was, he said. In your view, if that guidance gives more clarity to medical professionals across Northern Ireland, would that be enough to give the medical profession comfort that they can carry out the procedures that they believe are necessary, and therefore would the Minister consider not bringing forward legislation on the issue?
I think it really depends what the guidelines say. If the guidelines really deal with the existing case law, then I think the Minister's proposals would be going further than that, but still in the very limited circumstances of fatal fetal abnormality. But if the guidelines are confined, say, to the Bourne judgment, then there would be a difference between the guidelines and the Minister's proposals. But we haven't seen them, we don't know, so it's difficult to comment.
And I think that point is addressed in the actual proposals and in the paper, that there would still be a gap, and that the current case law would not necessarily work and would not actually offer clarity to women in the circumstances where they had a diagnosis of a fatal abnormality.
And the Minister's indicated he's now going to bring forward proposals to the Executive. When would he anticipate that will happen?
Just as quickly as we can follow the normal processes for that, Chair. This is a priority area for us now, and after today, subject obviously to what you say to us, we will be proceeding with that process.
Sure.
Thank you for bringing forward something which is a very sensitive and a very difficult subject for everyone and has been exercised at minds in Northern Ireland. And this isn't just to say it because the Minister is in the same political party as myself, but to say that I believe he genuinely has dealt with this matter incredibly sensitively in response to the responses that have been received, and the narrowing down of the areas that were under the initial consultation have now come down to probably the areas where, if you, and as the Chair said, if you listen to the people who have come and spoken to us, particularly Sarah Ewart and others, in respect of their very personal and very harrowing cases, then there is a clear and overwhelming need to legislate in this area, even in this very limited form. And perhaps there are others would like to see a much wider debate and aspect of the legislation, certainly I believe that this meets a very specific need. I have a question for you, and that is in respect of those that said that they felt that there should be some judicial oversight of the way forward, and those who suggest that it should be based on the opinion of 2 doctors. Could you just tease that out for us? And was there any interrelation between doctors and the judiciary? Were some people saying it should be a mixture of both? And why then come down on the side of the fact that the proposal is now that it should be on the opinion of medically qualified practitioners? Just in a final area, can you take us through the conscience opt-out, if you like, for those people who, in the medical profession, have a personal reason for not wishing to participate in a procedure?
Yeah.
Thank you. Chair.
Well, on the issue of judicial oversight and the number of doctors, I think we took what seemed to be the most the popular view of the medical professions and the professional bodies, that 2 doctors provides everyone with a degree of insurance that the diagnosis is agreed, and that we have, due to some concerns that were expressed from various bodies, we are considering putting into the legislation that the medical practitioners have a certain background in either obstetrics, gynecology, etc. In terms of judicial oversight, we could not see, and that was a suggestion that didn't come to us from very many respondents, but we could not see any benefit in putting a decision that it's clearly a clinical diagnosis being made by medical practitioners. How that could be anything but second-guessed by the judiciary, and it would be a step in a process that was unnecessary, would take time, and would not in any way help the person whom this legislation is designed to help, the woman herself who is going through this, and who is the one who is in crisis, and who has made it clear that she wants a termination. So we didn't think that that was an issue that bore any further investigation. Conscientious objection. Yes, there was a more or less unanimous desire from all respondents that there should be a right to conscientiously object. There were differences, varieties in how far that right should be available, and we have looked at those various responses, but the large majority of the medical professional bodies would want to see the conscientious objection only for those people who have a direct involvement in the actual procedure for termination, and that is backed up by the Supreme Court judgment in the Dugan and Wood case, which looked at the conscientious objection right under the legislation of the 1967 Act. That is what we would propose to do, that women who require medical care following a termination, there should not be an ability to say, no, I'm not prepared to look after this woman because she's got a termination.
Chair, thank you very much.
Okay. Sean?
Thank you, Chair. In relation to sexual crime, did the responses show some support in cases of this nature?
It was mixed. It tended to be, if an organisation or person didn't favour a change in the law for anything, obviously that came over into that issue as well. There was some support for the need to do something, but there was very little by way of ideas or suggestions on how a law could be framed. And you'll recall, Mr Lynch, that the consultation was very much in 2 parts. Part 1 was, here's a proposal, may we have views, and Part 2 was more along the idea of, could we have ideas and suggestions, how could a law be framed? So Chapter 9 has come to the conclusion that it's not possible to frame a proposal at this stage, and I think the Minister hasn't ruled it out, but it's not something he will move forward on in this mandate.
Yeah, given there does exist some support, why has the Minister not planned to legislate within this mandate?
Within this mandate, the time it would take us now to develop a workable policy proposal, consultation really came back with yes, support for the idea that something should be done on the part of some responses, but the responses tended to accept that it was going to be very difficult to put a justice provision and a medical provision together into a single framework to say, for instance, should a woman be required to have reported the crime to the police? What would happen if the case didn't proceed and the abortion had already taken place? Very complex area. We just wouldn't have time, I think, to develop a good, robust proposal in the amount of time we have left in the mandate.
Yeah, as the Chair said, it is a very complex area. Is there any timeline that the Minister would have to deal with this? Because it's an issue that needs to be dealt with, and it's your responsibility to deal with it.
We haven't got a timeline for it. It's something we just need to keep thinking about and working on, but I just don't think it's going to be possible to do something at the moment on that.
I just wanted to remind the committee members that in terms of the law on sexual crime and abortion for incest, as often referred to, that there is the upcoming judicial review by the Northern Ireland Human Rights Commission into the current law on abortion, which of course may have an impact on that area as well.
Okay. Paul.
Thank you, Chair. Thank you very much for your presentation. You mentioned that you separate the consultation, as the Chair has already asked. The questions are on the actual consultation, so I'll not cover that ground, but you separated the two parts or persons that would respond to the petition and the organisations. And you stated, I think, that 47 out of the 65 representative organisations were in favour of change. Can you give us a percentage of those organisations that actually stated that a change in the law was specifically what they required? You've used the terminology as a method of resolving this issue, which is very, very sensitive. You also used the word clarity. So method to resolve the issue and clarity around the issue are something that's very, very different from legislative change. So can you give us a percentage of those 65 organisations, 47 of which are supportive of change, 18 of which are not? Can you give us a percentage of the 47 that stated categorically that a change in the law was what they preferred?
I'm not sure that I can actually give you a percentage, certainly not off the top of my head at this point. But what I would say is that the proposals that they were responding on were proposals for legislative change, though they would not have been. I don't think that they were looking at how you might do this outside of that actual context. They were responding to proposals that would change the law, and off the top of my head, I can't think of anything specifically where they said we'd rather you did this by some other way. But I can't give you an exact percentage.
But again, that may not have developed because of maybe the wording of the consultation, which is very important. And I understand, I take your point about it being a proposal to change the law. But if 65 of these representative groups or organisations, many if not all of them, would have been medical based, surely.
A degree of them were, not all of them, no.
Well, the ones that were medically based would not only be looking at this in a legal sense, they'll also be looking at it around a medical sense and the guidelines that they're to, which they work to on a day-to-day basis.
Yeah.
So there may be other ways of resolving a thing or an issue, any issue, whatever it may be, not just a legislative one.
that didn't come across to me in the responses that they were looking at some other way of doing this. It really didn't. They responded to the questions in the consultation, which were about the proposal for a change in the law, and that's what they responded to. And I'm not, I can't say this for absolute sure, but I can't think of any that actually said there's another way that we can do it.
But if they're using the language of using a method, there are many methods for many things. If they're using the terminology of clarity, well, the law is clear now. So if they're seeking clarity, if the law is clear now, they're obviously not talking about the law.
Could I perhaps just refer to the first question in the consultation, which was, should the law allow for abortion in cases of lethal fetal abnormality? So I think we took their responses to be about the law, and the second question was, if so, how is this best achieved? So our reading is that there is support for changing the law as the way to provide clarity. But you're right, that there might have been an element, yes, there's a different way of doing this, that we didn't see that. There might be that view, but we didn't see that in this consultation.
Right, okay. Can I ask then on page 20, well, it's page 24 of our packs, it's point 11, with regards to the letter, it talks about the limited set of circumstances for termination is well defined and understood by the medical profession. The safeguard is clear. Where there is an ability to treat the condition, the statute exception will not apply. Now, obviously, we're talking about disabilities and illnesses, of course. But can I ask you around the question or the sentence where there is an ability to treat the condition, and of course, we're talking about the condition of the child. The statutory exception will not apply. And he's talking about, it's in the context of opening the floodgates around the law, and I hope you've grasped me there.
Yes, I have.
I'm sorry for being so patchy. But what does it mean to treat or the condition? Because people get treated for every and any condition, whether that's fatal or otherwise. Sometimes treatment does not prolong life. Sometimes treatment is all about making people comfortable.
Yeah.
So in this context, what does treating the condition mean? And because it's very important.
Yeah.
Because then the statutory exception will not apply. So it's fundamental.
Yeah. What it means is that at the point of the scan or at whatever point the clinical assessment is being made, the doctors, the practitioners, will at that point be making a decision that the condition, the fetal condition, is such that there is no treatment that they can offer which will make a different outcome, that the condition is fatal and that the pregnancy the fetus will either die in utero or it will die at birth, or that any live birth will only be for a very short period of time, and that there is no treatment that they can offer that will make a difference to that final outcome. And that is the clinical assessment at that sort of 20-week scan stage. That's what that means. So if there is it's to try and make sure that the condition is what the law will say it is, and that there is no ability with these proposals to have situations, which I think you're referring to, where a child might be born with severe disabilities, but that there would be treatment that could be used to ensure that life could continue. It's to make sure that rather than the wording of the 1967 Act, that this is very, very, very different.
But there are treatments there that may prolong life for a number of days, number of hours, number of weeks. There is also treatment out there that may well make someone's life comfortable.
Yeah. Yeah, and we have said that the inability to offer treatment does not. We're not talking about palliative care, care that if a woman decides to continue with the pregnancy to its natural conclusion, and if a child is born, that it does not mean that there can be no palliative care given to that child. Of course there will be, and we've made that very, very clear. But there is also, I don't have it here, so I couldn't find it in the timetable. But and you may find it in the document at some point, where I think it's either the GMC or the BMA has guidelines where it talks about when treatment should be offered in the neonatal period, where a child has got really severe disabilities, and that's a decision that is then made at that stage.
Yes.
But the same sort of issues apply. The doctor should know at the 20-week scan whether or not it is possible, whatever, to offer treatment that could make a difference to the actual outcome.
With regards to, moving on then to the conscientious objection, and I note very clearly here that you're saying that there should be no conscientious objection for all abortions, and of course abortions happen here in Northern Ireland lawfully. In a practical sense, how will someone who would wish to object and withdraw themselves, in a practical sense, how will that member of staff know the difference in the abortion setting and context? And I'm not using my words right here, and it's a very sensitive issue, so please excuse me, but how will they know in a practical sense when they're so busy and things are happening, and when they're in a surgery or in a midwifery or a room, how will they know, and how will they at that point be able to extract themselves without placing burden on other staff members and basically causing problems with logistics and staffing?
Well, I honestly think that is something that will have to be looked at. That's probably not an issue for the criminal law, but is an issue for the guidelines and guidance. That will be a matter for the Department of Health to if and when there is a clause, if this law is passed and there's a conscientious objection clause, the implementation of that clause and how it could be dealt with and implemented in the practical setting will be a matter for guidance, and will be a matter for the likes of the Royal College of Midwives, the Royal College of Nursing, the GMC, the BMA, to look at and operate, and the trusts to look at as well, to make sure that people are allowed to have their right to conscientious objection, but that the care of the patient has to be uppermost. And I think, although it's not statutory, at the minute there's no statutory ability to conscientiously object, there are still policies and guidance, administrative guidance and policies about how to try and to make sure that people aren't doing things they don't want to do. So I think that would be a matter for slightly further down the line than change to the law.
Okay, thank you very much. Thank you very much.
Okay, just before I go to Raymond, and you mentioned how that's an issue for health and not for justice, and it's one of those issues that actually I think most of us would probably think this is a health matter. It's unfortunate that criminal justice is looking at this area. But up until fairly recently, clinicians were comfortable enough being able to offer whatever support or whatever procedure for mothers who find themselves in these tragic circumstances. But they've found that the most recent guidelines have been perhaps more restrictive, and they're more afraid to offer the sort of advice that they were previously. If that is the case, then is it not a matter of amending the guidelines, and then it doesn't become a justice issue that there has to be legislation for it? I know I've sort of asked the question before, but it just strikes me that, and I've spoken to clinicians on the issue, and they feel as if it's a more recent thing, that they're more restrictive in what they can do. And my view on most issues is, like, if there are experts there taking decisions, I trust the expert. And if they're saying to us, like, it's not necessarily legislation we need, it's guidelines that allow us to do what we were doing prior to the most recent guidelines. Now, it's perhaps more of a question for officials in the Department for Health, and if it is, I apologise to you.
No, I think in a way, if you look at the case law and you look at the Bourne judgment, and if all the guidance and the guidelines can do is to follow that, and the case law within the criminal law is that the mother must, the woman, must have. There must be a serious risk to her life, or a serious risk to her mental or physical health, which is likely to be long-term or permanent. I think the health minister at the time made it clear that guidance could not, when that is the law, guidance could not address the question of people like Sarah Ewart, who were in those terrible circumstances and yet couldn't access a termination of pregnancy, and guidance could still not allow that to happen, because they are still going to have to make a judgment that the woman has got a serious risk, a long-term risk to her physical or mental health. That may not always be the case, but the circumstances at the time are circumstances were of extreme crisis and distress. That does not necessarily fall within the case law out of the Bourne judgment. And that is, when you have a chance to look at the paper, we've actually covered that in it. Raymond?
Thank you very much, Chair. And I suppose, in a sense, my first question will follow on from that. When the Minister of Health said that the guidance didn't cover it, did he make the case that there should be legislation, or would be only legislation could cover this?
Well, I think at that time the point was being made that if the guidance was changed to allow for fetal abnormality, then the cases such as Sarah Ewart's at the time would fall within that guidance. But he made the point that the guidance can only follow the criminal law as it stands and the case law, so it couldn't.
So it needed legislation for even to allow the guidance to be changed?
Yes.
Is that what you're saying?
Yes.
Yeah. Okay. In terms of taking it forward, have you used a timeline now as how it's going to be taken forward?
Just as quickly as we can move through the process.
Yeah.
So the next stage would be to bring a proposal to the executive, and we've taken some preparatory steps for, assuming we move ahead, how we start to put a bill together, and the process for that will be the normal process. There's not a lot of time left in the mandate, so that's why I say it's a priority for us. The Minister's been very clear he would like to move this forward, and that's what we'll do. But we just need to take each step now as we can, and the next step would be the executive.
Yeah, but in terms of taking it to the executive, will that be in proposal form, or will you have a draft bill?
We have to get executive permission to draft.
Do that, okay. And have you used a cut-off date where it'll run to such an extent then it won't be covered in this mandate?
Yeah, I think the normal process would be, the normal way of thinking of this would be, if we could introduce a bill prior to summer recess, then a bill would have a reasonable chance. So we must try for that. But I wouldn't say that if we don't make it before summer, there's no prospect. It's just that would be the normal way of thinking about it. But we would imagine this to be a bill dealing with just this subject matter. We wouldn't intend to align it with other provisions. And the Minister would think that this is of such importance it needs to be deserved in its own time and its own space in this mandate.
And have you any sort of sense of what size the bill would be? I suppose that maybe in terms of clauses or anything like that wouldn't be, you say it's short or a long?
It's very short.
Short bill, okay. Thank you, Chair.
Okay, Alban?
Thank you very much, Chair, and thank you for your presentation today. Just in relation to conscientious objection, there was a specific proposal that the right should extend to institutions rather than individuals. I don't see that as part of the proposal for legislation. Would you like to comment on it?
That was a suggestion from, as far as I can remember, though I may be wrong, from one respondent. Didn't.
Catholic bishops?
Yes.
Yes.
We don't think that that was reflective of the responses that we got on that subject.
That would mean, if you take, for example, the Mater Hospital, whose Catholic ethos is protected in law, that ethos could in fact be seriously damaged by your proposed legislation. There would be no protection there for that institution.
There would be the same protection for the staff there as there would be in any other hospital.
Yes, but there's no protection for that institution.
Not in the proposal, no.
Despite the fact that in law the Catholic ethos is protected. Can you reconcile that with the current position?
In what way?
Well, there is a protected ethos, Catholic ethos, in relation to the Mater Hospital. How can you protect that ethos and still not have institutional protection?
I think if every member of staff engaged in this area of women's health didn't want to participate, then they would have the same right of conscientious objection.
Yes, but that's not the point, and you know it's not the point. The point is the institution itself. How is the institution itself protected in the context of your proposals?
It wouldn't be.
It's not.
It wouldn't be, yes. And that's precisely the point I'm making. And I would advise you to look again at that,
Okay.
because I think it's a very, very important point. Just in relation to the what is proposed in terms of fetal abnormality, there would be a statutory exception. Is that based on option 4? And in what respect is it based on option 4?
It's it would be
Option 4, perhaps if you look at option 4, incompatibility with life, that was the basic substantive feature of option 4. That was the that was the test.
Well, that was part of it, but it was also the option 4 was about it being based on clinical assessment, on the assessment, on the clinical judgment of medical practitioners at the 20-week scan.
Yes.
We had some responses about the terminology used.
Yes.
And we have, as you see in, I'm just trying to find where it is on your paper, in paragraph 12 of your paper, that the proposed legislative framework is now slightly different in terms of its terminology. It talks about a fetal abnormality which is likely to prove fatal, and where continuance of the pregnancy would be likely to have a detrimental effect on the health and well-being of the woman. And in relation to the diagnosis of the fetal abnormality, an assessment must be made by 2 suitably qualified medical practitioners that the condition is likely to cause death either before birth, during birth, or an initial period after birth. And in the event of a child being born alive, there would be no medical treatment other than appropriate palliative and nursing care, which was mentioned earlier, which could be offered to treat the condition in order to substantially improve the chances of survival. So there was a degree of concern about the wording in terms of incompatibility with life, and as the original consultation document produced proposals, not a definite legislative framework, we have now refined somewhat, and this is still not the actual legislative.
So you've removed incompatibility with
Yes.
life. That's
Yes.
been removed. And you're saying that makes no difference really to the original option 4?
No, I would say it
Well,
doesn't.
what's the difference? I'm trying to probe the difference.
Well, I think this, paragraph 12
Yes.
is trying to make it as clear as possible what the test is whenever a termination of pregnancy
Yeah.
is an option in a particular set of circumstances. And as a result of the consultation and a result of the responses from the medical practitioners, we have put together the proposed legislative framework as in paragraph 12 to set out precisely what the medical assessment would have to be at the 20-week scan.
Yes. Can I ask you a further?
And it may change again in the process of having a legislation
I
drafted.
get the general drift. I'm just trying to probe. It also says where a diagnosis be made of fetal abnormality, which is likely to prove fatal, and the continuance of the pregnancy would be likely to have a detrimental effect on the health and well-being of the woman. So there's two tests there. There's one. You have to establish that there is fetal abnormality.
That's the test.
That's the first part of the test. Is that correct?
Well, that's the test, yeah.
No, it's not the test. It's one part of the test.
Well, the detrimental...
No, sorry.
Yeah.
Just to make it clear to you, I'm not trying to trick you. I'm trying to understand what you're putting forward.
Yeah.
You're saying that you establish fetal abnormality, and then the continuance of the pregnancy will be likely to have a detrimental effect on the health and well-being of the woman. So there's two aspects to the test.
Aspects, yeah.
And you agree with that?
Two aspects.
Two
yes.
aspects, yes. Okay. Now, just in relation to the Northern Ireland Committee of the Royal College of Obstetricians and Gynecologists, I'm unclear. They rejected options 1, 2 and 3. Option 4. Did they accept option 4, or did they reject it, or did they qualify it?
Qualified it.
They qualified it. And in what respect did they qualify it?
I think that from that you'll find similar wording about the detrimental effect on the health and well-being of the woman.
Yes, but what about the test of incompatibility? What did they say about that?
Well, we have removed that incompatibility of life.
But what did they say?
Well, I don't have it open in front
Okay.
of me, sorry.
Right. But I would suggest to you that they weren't happy with that particular approach.
Yeah.
And expressed that it was unclear.
Yes, correct.
So they didn't accept option 4.
Well, they accepted it, only they wanted it worded in a different way. And as I was trying to say, the proposals in the consultation document were purely that. They were proposals for us to work on and to amend as a result of responses.
Yes, but they
We
didn't
have
accept.
done.
They didn't accept option 4. That's the point I'm making to you.
I think they did.
Well, how could they if they were saying it was unclear and the test of incompatibility?
As it was drafted in the original consultation document, parts of it were unclear, but I think they were very much in agreement that the decision as in terms of a termination should be on the basis of a clinical judgment at the 20-week scan or thereabouts. And not on the other 3 options that were put forward.
Well, we can ask them about that, whether in fact they accepted option 4 or not. But you're saying anyway you're going essentially with option 4, but you've changed option
Yes.
4. And I'm still unclear as to how you've changed it, but leave it there. But one final point is this. Supposing we had this statutory change introduced, what limit would there be in terms of time on the termination of a pregnancy in such a situation?
We have not proposed, as you
So
can
it goes up to birth,
to put a limit on
just
time.
pre-birth,
We haven't proposed to put a limit.
absolutely no time limit.
And none of the responses from any of the medical bodies or medical practitioners argued in favour of putting a particular time limit.
Which is curious.
Well,
I'm saying it's curious. You mightn't agree with me, but so we would have the same situation as we have in England under the amended 1967 Act, where you can abort an abnormal fetus right up to birth. Is that right?
yeah, but the big difference is that the reason why there is no, that I'm assuming that the responses did not argue for a time limit is because of the particular circumstances, the very specific circumstances that we're proposing in here, that this should only occur when a decision has been made that there is going to be no life after birth. And therefore, it becomes...
But there will be life after birth.
Well, not in terms of where it becomes sustainable life. We're talking about during
Is there a
birth
difference?
or
Can I
death,
just ask you?
in utero, and it's on the basis of a likelihood. It's on the basis that the assessment is that there is no likelihood, that little likelihood that this will happen, other than either death in utero, a stillbirth, or shortly after birth.
Could you define sustainable life after birth?
Well, we haven't used sustainable life after birth. We're talking about life in an initial period after birth.
Yes.
And therefore, the issue of a time limit doesn't really have a relevance in that context.
Yeah. Well, I think it does have relevance, and I think that the vast majority of people would say it does have relevance.
Well,
we'll agree to disagree on that.
For example, if a person with an anencephalic pregnancy didn't find that out until 25 weeks, does it mean then that there should be no, and the person was extremely distressed and upset and requested a termination, that they would not be able to have it at 25 weeks, but they would have been able to have it at 20 weeks?
Just one last point in relation to the consultation. I mean, it does seem to me, and perhaps to others, that this was a preordained outcome to it. But have you given too much weight, disproportionate weight, to the medical people that commented upon the consultation?
Don't believe so. The ministers had access to see the full range of views. I think he says in Chapter 8 that he's been very mindful and very respectful of the range of views that have come forward for and against change, but he has to come down in favour of where he thinks the criminal law should be. He's given weight to all of this, to the number, the nature, the quantity of responses, and this is where he thinks we should go next.
So what you're saying that there wasn't disproportionate weight given to the medical profession?
We don't believe so. No, that's part of the weight of evidence. Mm-hmm. He's put some weight on that, obviously, but we wouldn't agree.
Thank you very much, Chair.
Tom?
Chair, thank you, and apologies for missing your presentation. But very quickly, and if you have addressed this, haven't had time to go through all the responses, but have you had any responses, or were there any responses to consultation from women or ladies who found themselves in the position?
Yeah, there was.
Yes. And were all of those responses of a similar nature then? Did they agree, or were they opposing?
No, we do try to bring out personal experiences in both sides of the argument. Some people would say, speaking from similar position as Sarah Ewart, there are other ladies who felt that it was absolutely right for those to continue with their pregnancy, and we heard both of those experiences, and they're both reflected in the.
Okay. And the medical profession, by and large, is in support of a proposal to change. Is that right? By and large. Okay. And sorry, just finally, could you explain a wee bit more again? If you've done this, apologies. Around the conscience issue within it, could you just explain a wee bit about that?
The proposal, the responses, to the consultation were more or less unanimously in favour of a right to conscientious objection, but that varied in the application of that right considerably. But
Sorry, varied in what way?
in to what extent you could buy that right? Should it be for all aspects of medical care and medical administration, from cleaning the ward to arranging the appointments, to all of that, or should it just be in terms of the procedure for termination? And the proposal is that, given the Supreme Court judgment, we and various other, not just that, but proposal is for a right of conscientious objection for direct involvement in the procedure of termination.
Okay. And the timescale for bringing any proposals to the executive now?
As soon as possible.
That is our next process step, which is to bring a proposal to the executive. We will aim to do that as quickly as possible, and we were explaining earlier the normal time frame would be to try and get a bill introduced before the summer recess. Whether we can do that or not is depending on time. But yes, going to the executive is our next step, and we aim to do that quickly.
You say quickly within...
I would, yeah, well, absolutely certain. I wouldn't want to put a date on it and then say that we've missed the date. All I can say, as said earlier, it is a priority for the department. It's a priority for the minister.
Okay. All right. Thank you. Thanks, Chair.
Okay. Edwin?
Thank you, Chair. At the outset, I would caution Ms Patterson about putting words in my mouth in a response to Mr McCartney, which are wholly inaccurate. And I'm quite capable of answering any questions on that issue, but will not have Ms Patterson wrongly reflecting my views and my position relating to guidelines and relating to legislation.
Sorry, Mr Pearce, if we've got something wrong, we'll address it now.
Well, I would caution you that you were wholly wrong in terms of your response to Mr McCartney. And if you care to look at Hansard and seek to identify where I have stated that position, you will not find it. So I expect greater care being taken by senior civil servants in that respect and given evidence to a committee, because it doesn't actually strengthen your case whenever you actually make inaccurate comments. In terms of...
Sorry, do you wish us to deal with that now, Mr Pearce? I'm sorry if we've got something
Well,
wrong.
I don't think it can be dealt with. It is on the record. I'm on the record now as having challenged that position and have urged you to identify where that has been said in a public way. In terms of the actual consultation, Mr Chairman, could I ask how much this consultation exercise cost?
Well, there were no costs outside of those from our own time. And the time taken to prepare the documents within the department. If what you mean, Mr Pearce, is did we spend any money on external assistance with this? No,
okay.
It's departmental time.
And what is the purpose of a public consultation?
Seek public views.
Okay. Maybe you just go through the figures quickly there again on the public viewpoint.
On what?
On what the expressions were. Many people indicated that they were opposed to this.
They are in your
Yes, I know,
paper.
but I would like to put them on the record.
Well, there were. Do you want me to run through the figures here?
Yeah, please.
There were 712 individually written responses from members of the public. 579 of those were against change and 133 were in support of change. There were 65 responses from representative organisations and interested groups. 47 of these supported change and 18 were against. There were 921 letters opposing change written in support of 7 lobby campaigns. and there were 23,622 petition signatures opposing change.
Yeah. I think you'll find the figures will tally up to something like this. 99.3% of people who responded were opposed, 0.7% were in favour. If you remove the petition from it, 89.4% of people expressing an interest were opposed, with 10.6% supporting it. And if you drill down to organisations, it is 72.3% opposed, with 27.7% in favour. So you've engaged in a public consultation exercise and then chosen just to ignore the outcome of that consultation. So, you know, what was the point of a public consultation if you weren't going to pay any attention whatsoever to what was being said to you?
I think the purpose of the consultation exercise and the purpose of this very lengthy and comprehensive document was to present a response to that consultation exercise, and we have been very open and transparent in what we have included in that document. The figures quoted were signatures to a petition which said one thing. We were not able to establish whether that petition, which was organised by an organisation from based in Dublin, we can't guarantee that all the signatures were from addresses in Northern Ireland. And we also had to take account of the fact that the 65 responses from the representative organisations were just that, representative organisations representing a large number of people and a large swathe of opinion across society. We have mentioned this, all of this, in the summary of responses to the consultation. What way we have given weight to particular responses. We faithfully tried to reflect those responses. But at the end of it, this was not a consultation, it was not a referendum, and it was not about working out how many people said one thing and how many people said the other. It was to look at arguments and positions and decide on the substance and content and weight of those arguments.
Yes, and excluding the petition, which one of the issues that you're concerned with for potentially people out of state having signed, you still were having almost 90% opposed to change, or 10% were for.
Well, that is if you disregard the fact that the 65 responses were from organisations representing a large number of opinion, which you can't then. We can't just work out how many people those 65 responses were coming from, but they represented a large number of people.
Yes.
But having said that, the consultation was not about finding out how many people were in support or how many people were against. It was about looking at the arguments and the weight of the arguments. And if you look, and we have, I think, put this in the document as well, the figure of the total figure, 25,000 or whatever it was, works out at something like, and I can't really remember here, but I think it's something like 2% of the adult population in Ireland. So if you want to look at percentages, it becomes difficult then to just respond to a consultation on the basis of figures like that.
Well, certainly when you go to public consultation and you don't like the outcome, that's a line that you would be likely to take. And in terms then of it, you've decided to proceed with recommending option 4?
A version of it.
A version of option 4. RCN would have preferred option 3, and the obstetricians preferred option 4, but not, as you indicated, that was qualified support.
Yep.
So you've been happy to ignore everybody else and go for something which is qualified support of one particular group?
I don't think that's the case.
Not the case.
No, I think the Minister's looked at the totality of what he's got here, and that's the basis for his.
I think, Chairman, it's hard to deviate from. We had decided to go down this particular route, and legally we have to have a public consultation process. Having conducted the process, we will go down the route that we had decided to go down in the first instance, and pay absolutely scant regard for the views of the public that have came forward.
That's not
I
the
think
position.
if the consultation document would suggest that the Minister has in fact looked at a lot of the concerns that were raised from those people who were opposed to any change in the law, and those concerns have been addressed quite comprehensively in the document.
Okay, thank you, Chair.
Okay. Patsy?
Yes, Chair, thanks very much. I'd like to go back there to something that we were discussing in the context of what Mr McGuinness said. Just picking up on the theme of life, could you give me what the department's definition is of what constitutes a human life, both post and pre-birth? Because you did take us into that arena earlier.
This came up last time we were here.
Beg pardon?
This came up last time we were here in the launch of the consultation exercise, and I think it was me that, rather than Amanda, had said at that time, that really is not a DOJ issue. We're not medical people. We're not qualified to give a view on that. We're here to talk about the criminal law. It was maybe unsatisfactory. We didn't answer it last time, but we're not in a position to give a view this time either, I'm afraid.
And
Okay, so can I ask just, are you prepared to seek advice around what that is? Because you're prepared to, obviously, I've heard you heavily reliant on advice of other key stakeholders in the medical profession and the like.
I think that the Minister's position is quite clear in terms of this consultation. It's set out in the summary document that this is only about the limited circumstances of a fetal abnormality which is likely to cause death either before birth, during birth or an initial period after birth. And the Minister's view is that in those circumstances, in those very strict set of circumstances, the health and well-being of the woman must take priority. And I think that's been set out in the document, and I think that's as far as the Department and the Minister's position is available.
So, just to get it clear and for the record, the Department has not sought any advice as to what constitutes a human being, either pre or post-birth,
Not
or a human life.
Well, there are varying views on where that is, and in terms of this particular context and the specific circumstances of this consultation, it was made clear in the initial document, in the consultation document, that the debate on issues of that nature we were not opening up the debate on those issues. And I think that's as far as we can go today. The Minister's position he has made it clear in terms of the context of this particular consultation.
I respect you here representing the Department, so the answer is no then. Okay. Right, thanks very much, Chair.
Anyone else? So, thank you very much. Appreciate your time. Thank you. Members, if we can move on then to Agenda 5, it's our second oral presentation. Officials will attend to outline the results of the consultation on the introduction of a statutory registration scheme for all providers of publicly funded legal services in Northern Ireland and the proposed way forward. If you just refer members to pages 310 through to 527 of your meeting folder. And just as the officials are taking their seats, can I welcome Mark McGuckin, the other Mark McGuckin, Bridget McCabe and Kim Elliott. And as always, just to let you know that we're being recorded and will be published in due course. I just also remind members that make sure their phones are turned off because it is interfering with the recording equipment. I'm asked to do that, so I'm glancing around, see quite a few mobile devices in use at present, so you would just cease to do that for a little bit of time. And just whenever you're ready, if you want to go ahead, and then we'll open up the questions.
Thank you very much, Chairman, for your introduction, and I'm grateful to the committee for the opportunity to come to address any questions about progress and plans in respect of the introduction of a statutory registration scheme. The committee has in front of it the post-consultation report, and we will be happy to take any of those questions. But very briefly, before doing so, it might be useful to reflect on why we're introducing a registration scheme for legal professionals engaged in delivering legal aid work. The Legal Aid Fund pays for solicitors and barristers in private practice and in the voluntary sector to provide legal advice and representation for citizens subject to certain criteria. Best practice and experience in other jurisdictions would suggest that arrangements should be put in place to provide assurance about the quality of the service and about the propriety and regularity of the use of public funds. A number of external reviewers have commented on the need for improved levels of assurance. For example, the Public Accounts Committee recommended the introduction of a compulsory registration scheme and a comprehensive quality assurance system for all individuals wishing to provide publicly funded legal services. The registration scheme set out in these papers will contribute to the delivery of that recommendation. It's important to be clear that the focus of the scheme is about obtaining assurance about the quality of service provision. You will have noted in the papers that where an audit identifies issues of non-compliance, the intention is to work with the provider in order to address any shortcomings. It's not about reducing the number of potential providers or about restricting the choice of the individual client. It's about giving a level of assurance to the client. You will have noted that we plan to take this work forward in several phases, though those phases will overlap. The first phase is to get the scheme in place and the registration and the codes of conduct to allow self-certification of compliance with the requisite policies and procedures. As this is being done, we will also be progressing the detailed proposals for audit and assurance with a view to bringing these forward at an early stage. Finally, it's worth pointing out that the registration process will form part of the new digital case management system being introduced by the Legal Services Agency. This will be of significant operational utility to the legal profession, as well as enhancing the processing capacity within the new agency. Mr Chairman, in bringing forward these proposals, we have consulted extensively with the legal profession and engaged with their respective representative bodies. We've adjusted the proposals in response to the representations made to us. There are still some issues which need to be finalised, and these will be delivered in the subsequent phases, and each of those issues will be subject to further consultation with the legal profession. So with that brief introduction, happy to take any questions that the committee might have.
Okay. I just got a couple of questions. You mentioned in the papers about the level of engagement with the Bar Council on this, and you wanted to have similar with the solicitors' representatives. Is there a reason why the Law Society haven't been as engaged, or have they any particular issues around the proposals?
Well, I think it's fair to say that the Law Society were engaged at an early stage and, in fact, worked along with the Legal Services Commission previously in the development and running of a pilot. And as part of that pilot, the draft code of practice was drawn up in consultation with them. They didn't engage quite as closely, and we would have welcomed a couple more discussions with them on the final outworkings of it, but I think they're quite committed to taking this process forward. The Bar, on the other hand, hadn't been involved in the initial pilot, so we're working from a different premise, and we're very keen to engage, and did engage with us very effectively over the process and in the development of the code of practice as it would apply to barristers in going forward.
And what's the timescale for full implementation of the registration scheme?
Our aim is we need to take this through a draft affirmative procedure, so our aim is to pull together the draft regulations and have those ready for consultation by June, July time, and consult with the profession on the specific detail. They're all aware of the principles and everything else, and then bring that in through the assembly processes. We want to try and tie this up as much as possible, if we can, with the Bar Council and the Law Society's own certification processes. And the Law Society certifications is in February each year, the Bar slightly later than that. So we would plan to try and have the initial registration in place for next February. At the same time as we're working through that, we'll be working through the details of audit and so on, and those proposals will be coming forward and rolled out subsequently.
Thank you very much, Chair. Just in relation, in the In the paper presented, it says that they are subject to sanctions for non-compliance.
They're currently subject to sanctions in terms of their own codes of practice within the regulatory bodies. But certainly, the code of practice, as set out in these documents, doesn't apply yet. So clearly, they can't comply with that. I mean, if there are issues that need to be addressed currently, if that come to the attention of the Legal Services Agency, the Chief Executive would draw those to the attention of the Bar Council or the Law Society, and it would be a matter for them as to how those were progressed. But they would be within the internal regulatory mechanisms of those two bodies, and not specifically related to the resources in relation to legal aid.
So the registration scheme will still, there's not going to be an outside external code of practice. It's the code of practice as pertains to the two professions.
No, the draft codes of practice which relate to organisations who will be engaged in delivering legal aid at work are attached to the post-consultation document. Those are the two drafts, are the two codes of practice that we would aim to introduce. They are certainly consistent, as you would expect, with the existing codes of practice of the two bodies.
I mustn't be making myself clear. I'm just saying, if the registration scheme is up and running,
yes,
and it's found, now I want to be prejudging that about, but if it's found or non-compliance, who deals with the non-compliance, the profession or the registration scheme at the department?
Well, it'll be the registration scheme at the department. As I said in the open comments, our aim here is to ensure that people provide the necessary level of service and the appropriate regularity and propriety around the expenditure from the legal aid fund. This is not about excluding people from the provision of legal aid or providing those services. And initially what we would seek to do is to work with, if we identify issues of non-compliance, to work with the solicitors or the barrister involved in order to address the reasons for the non-compliance so that they are compliant. And it would only be if you get through a process which is quite elongated and explained in the post-consultation report. It's only if you get to the end of that and the individual or the firm isn't continuing not to comply that you would be considering excluding them from providing legal aid at work. It's about actually trying to improve and to get people into compliance.
So the reason I'm asked that the Law Centre and the Citizens Advice Bureau will be involved in the scheme?
They will indeed, yes.
So, I mean, that's why I'm saying, if there was non-compliance here, it's easier to see how you can be, if the two professionals, I'm not saying they would, said, well, it's not outside our code of practice, maybe outside your...
Oh, no, we've worked very closely with them in relation to this, and the two things are consistent.
Okay, Tom?
Chair, thanks for the presentation. A couple of queries just. Is it possible for a solicitor within a firm to be non-compliant, but the firm compliant?
That's a level of detail which we would need to work through, and if you were getting to that stage, yes, you could find yourself in a position where a solicitor would be non-compliant, but other members of the firm would be compliant and continue to work. What we are suggesting in situations where it's a firm where a number of people are in a practice or a limited company or however they're structured is that you would have a compliance partner who would be the key person that we would be that the Legal Services Agency would engage with, and they would have responsibility for ensuring compliance of the firm and compliance of each of the individuals. And you would, if the firm was compliant and the other members of the firm were compliant, you would like to think that they would be working along with the individual to help them to come into compliance.
Would it be possible for an individual or a firm to be non-compliant for legal aid purposes, but could be compliant to continue practising as a solicitor or barrister?
It's a matter for the two regulatory bodies as to whether or not they certify them for other activities, and I think that would be a question that you would need to put to them. Certainly, currently, for each of those two bodies, as I understand it, there are circumstances in which they could give a certificate in certain limited areas. So an individual might be certified to provide certain types of legal advice, but not others. So that sort of situation currently arises.
I think the potential is there for an individual to be deregistered from the scheme, from the registration scheme, but they may still have older practice certificate, still carry out privately paperwork.
Okay. And would it be possible that a client could have engaged a solicitor or barrister that have got part way through a case, or maybe even completed the case, and then they would find that the solicitor or barrister was non-compliant and then not be awarded the legal aid? Is that possible?
Well, the legal aid, the payments are going to the solicitor, but no, I don't think that would be possible, because I think, particularly as we're lining the registration scheme up as the front end of the case management, the new digitalised case management system. So the two things will work seamlessly together. Once solicitors are registered, then that will be apparent. If they're applying for legal aid, and they have to apply for legal aid before they do the work for their client, then it will become quite clear that a certificate won't be awarded if they have not been compliant, or if they're currently not registered and have been deregistered because they haven't been compliant.
So there's nothing could happen in between? They wouldn't have any other applications to make in between?
Well, there's a potential, of course, that somebody could go through the process of being audited, and the legal services agency working with that individual or working with that firm to help them to become compliant, and they will have carriage of a number of cases at that particular point in time. One of the details that we would need to work out as we're going through this, what would happen to the carriage of those cases if they subsequently become deregistered because they haven't been compliant. But I think we're talking here at the very extreme end of the process. I mean, the purpose of this is to drive up standards and ensure that people achieve the appropriate standards. It would only be in the very extreme circumstances that you're actually talking about deregistering somebody from provision of legal aid. In the same way as it's very extreme circumstances where they lose their practising certificate currently.
We have said in the consultation document, if that did apply, that it would be the solicitor's responsibility to ensure the carriage of the case is passed to someone else. So it is sort of highlighted in here, and it would be the responsibility to pass those cases on.
And this would be an issue that the Law Society would be taking a close interest in as well as in terms of their responsibilities.
Okay, thank you. Thank you, Chair.
Well, thank you very much, Chair. It's great to see peace and amity between the lawyers and the department. Congratulations on your good work, Mark. I do think it's an important initiative to try and introduce, perhaps a greater quality assurance to the consumer, who's ultimately you and me when we seek legal services through legal aid. But I'm concerned slightly that with small firms of solicitors that you might impose too great a degree of bureaucracy and regulation, which a larger firm would regard as inconsequential. Could you reassure practitioners that that would not be the case?
I think that what is being set out in the Code of Practice is what an individual firm, an individual who's part of an individual who's part of a firm would expect to see now. And I think in terms of policies going through, clearly there'll be slightly different application of those in a large firm with many partners and many support staff, and you would expect a further degree of formality around that. You'll still want to see the policies in place, and certainly support will be given in terms of draft policies which can be applied and adopted and or adapted by the smaller firms. So there will be a lot of support in there to
So you are cognizant of the smaller firm and the burdens that might be imposed upon them. Just in relation to the fee that will be prescribed in relation to the scheme, is this a notional fee or is it something more substantive?
Can you define notional for me?
15% of their
That's what I was thinking about.
Dear. We're working through the proposals for a fee. In terms of what we want to try to achieve here is to make the running of this cost neutral.
Yes.
We're currently setting up systems, we're setting up the IT system and so on, which will allow this to happen, and that will be integrated into the case management system. We're not proposing to cover any of those costs. And in effect, what we're looking at is the ongoing costs of carrying out audits in each of the solicitors. The fee will be dependent ultimately on the number of firms and the number of individuals who actually register, and what the audit process is. We're currently working through, and there are a number of different options in how you would carry out this audit, whether you audit every single firm every 3 years, whether you apply a risk-based approach, an approach based on the level of funds being drawn from the legal aid fund, yes, so that you're auditing those areas who are pulling down the most funds more regularly than others, and perhaps others would only get audited on an ad hoc basis. Yes. But what you want to do is an audit which is proportionate. It might be slightly higher at the start until we see how all of this works out and how compliance works through. So those are the sorts of factors that we're working through at the moment in order to determine the overall fee. I would say, I wouldn't use your word necessarily, but I would hope that the fee would be modest, and it is only about recovering the cost of those audits going forward.
I'll accept modest. Thanks very much, Chair.
Patsy?
Yeah, Chair, I'm sorry, excuse me, I had to go out and take a phone call earlier there, but can I just ask, there was one thing, and this has been raised with me in regard to this, it may well have been raised before, so my apologies for that. Costs issue, any attributable costs that might be associated with this, for example, around code of practice, adherence to standards, facilitating audits of compliance and the likes of that. Have you picked up on that or assessed what that might be?
On the and that's what I was just saying. The cost to the practice.
Yes, cost to practices.
We wouldn't envisage that applying the code of practice would attract any additional cost. The code of practice sets out best practice on what people should, we would expect people to be doing already in terms of their own regulation and in terms of their financial checks and so on that they should be conducting, and the records that they should be keeping for their own purposes. So we wouldn't envisage any additional costs. Mr McGuinness was asking us about the impact on smaller firms of developing policies and so on, and our intention there is to be able to provide some standard basic policies that people could adapt for their own purposes, so that would reduce any particular overhead. You mentioned the cost of audits, and that is one of the areas that is the area that we would like to be recovering through the fee system. We're currently working through what the audit process might look like, and the fees will be dependent then clearly on the number of firms and the number of individual solicitors and barristers that actually register and the frequency of the audit. So we're still working through that process currently.
Right. So you just don't know on that one yet?
Well, the best I'm prepared to say at the moment is the fees should be modest, and it will be limited to recovering the cost of undertaking the audits.
All right. And when are you likely to know those fees, those proposed fees?
We're working through. The initial stage is to get the rules drafted and brought before the Assembly, and it's a draft affirmative procedure. And while we're doing that, we're working through the process of finalising our proposals in respect of how the audit would be conducted, the frequency of it, and how it would be targeted. And we'll go back and talk to the profession about that, and that will then help to drive the fees. And we will have an indication then of the order of the fees. Now, it'll vary at the margins depending on the frequency of audit and actually the number of firms and individuals that come forward to be registered.
Okay. Thank you. Thanks, Chair.
Nobody else has indicated, so thank you very much. Appreciate that.
Thank you.
Okay, members, move on to agenda item 6. Officials will attend again to outline a number of proposals on statute rules that will reform police discipline and satisfactory performance procedures. The relevant papers are at pages 529 to 539 of your meeting folders. Can I welcome Lorraine Montgomery, Leslie McComb, and again to remind you that we're being recorded by Hansard and will be up on the committee website in due course whenever you're ready if you want to outline a few comments, and then we'll open up the question.
Thank you very much, Chair. I welcome the opportunity to brief the committee on the proposed new regulations for the reform of police discipline and unsatisfactory performance procedures within the PSNI. At the outset, I would note that the new regulations are intended to ensure that misconduct and poor performance is effectively managed within the PSNI in a way which is proportionate, without unnecessary bureaucracy, and no less robust than those procedures currently in place. It may be helpful if I briefly rehearse some of the background to the reforms before taking any questions the committee might have. The Department routinely considers the relevance to Northern Ireland of policy developments in England and Wales affecting the regulatory framework for police officers. New police discipline and performance arrangements were introduced in England and Wales following a review commissioned by the Home Office, and the report, which was known as the Taylor Report, found the previous arrangements were too lengthy, costly and heavily regulated. Having considered the changes within existing procedures and convinced of the operational benefits gained from the reform in England and Wales, the PSNI indicated it was keen to introduce similar reforms in Northern Ireland. The legislative basis is currently set out in 3 sets of it is set out in 3 sets of primary legislation, namely the Police Northern Ireland Act of 1998 and the later Police Acts of 2000 and 2003. A number of sets of regulations exist through secondary legislation which underpin the procedures for police conduct and performance, as well as the police complaint system in Northern Ireland. It is intended that these reforms will revoke and replace 4 sets of secondary legislation, namely the RUC Conduct Regulations 2000, the RUC Conduct for Senior Officers Regulations 2000, the RUC Appeals Regulations 2000, and the Police Unsatisfactory Performance and Attendance Regulations Northern Ireland 2010. It's recognised that there are a number of difficulties with the current police discipline and unsatisfactory performance system in Northern Ireland. The current system has been described as overly bureaucratic and legalistic, with little or no encouragement for managers to swiftly and proportionately deal with low-level misconduct matters. It has also been criticised as unnecessarily burdensome and costly, both in terms of management time and the overall time taken to conclude the process. Misconduct hearings have often been categorised by legal arguments on technicalities rather than focusing on whether the conduct of an officer has or has not in fact been acceptable. The key difficulties including the requirement to await the conclusion of criminal proceedings before those procedures can progress, and this has resulted in considerable delays, often spanning several years, during which officers are suspended on full pay. These reforms will enable misconduct proceedings to continue in advance of criminal matters, providing that this does not prejudice the case. In addition, less serious instances of misconduct will be dealt with at a lower management level, as opposed to the current system, which brings these less serious matters to costly and time-consuming hearings. It's believed that the PSNI will deliver efficiencies through implementation of the reforms. The benefits will be realised principally through a more efficient process, including a projected reduction in periods of officer suspension, and increased powers at a local level, which itself should result in fewer misconduct hearings. The ability to complete the disciplinary process in advance of the criminal proceedings is a key enabler to the reduction of suspension periods. There will be investment associated with training and implementation, which the PSNI plans to absorb within its existing budget. The new regulations will revoke and replace 4 sets of existing regulations setting out the performance and attendance, conduct and appeals procedures. The intention is to introduce 3 sets of regulations governing these procedures. The reforms will introduce a number of changes to the discipline and performance procedures for police officers. Some of the key changes have been outlined in the SL1, and I'll very briefly attempt to summarise those for you. I should note at the outset that the standard of proof in disciplinary cases will not change and remains as it is currently on the balance of probabilities. At the moment, there are separate regulations governing misconduct procedures for senior officers. These will be incorporated into a single set of regulations for officers at all ranks. The Northern Ireland Policing Board will retain the role of appropriate authority in cases where there is a report of misconduct in respect of senior officers. The new conduct regulations will introduce a requirement for an assessment of the conduct which is the subject of the allegation at an early stage of the process. This initial assessment will determine if the procedures should be invoked and, if so, which should be applied. This early evaluation will allow the matter to progress proportionately by defining whether it requires investigation, further management action or no action. Disciplinary proceedings will be able to progress before criminal proceedings have concluded, providing this does not prejudice the case. The existing conduct regulations currently prohibit this. The sanctions available following disciplinary proceedings will no longer include financial penalties, such as a fine or a reduction in pay. The new regulations will split the sanctions available into two separate categories, one for misconduct, the other for gross misconduct, where the sanctions available will be reflective of the level of conduct being considered. The reforms will not include an interim mechanism for review by the Chief Constable following misconduct proceedings. This, however, will not affect an officer's right to appeal to a police appeals tribunal, which will be maintained. The Ombudsman will remain entitled to attend a misconduct hearing as an observer where proceedings have been brought about as a result of an investigation by his office. Officers will no longer have the right to object to his attendance, although a condition has been introduced that the Ombudsman may withdraw from the hearing whilst mitigating factors are cited. The reforms will introduce changes in the composition of disciplinary performance and appeals panels. These are intended to streamline the process and allow panels to be convened more expediently. A provision will be introduced to allow the review of a police appeal tribunal's determination within a specified period and subject to certain strict conditions. It's not intended to be an automatic right if the officer is not content with the panel's determination, and a strict criteria must be met. A police appeals tribunal will have the power to impose any sanction available to the original disciplinary hearing, which includes the option to worsen the sanction on appeal. In summary, since the first draft regulations were provided to the committee in 2013, there has been no change to the policy intent. The regulations have, however, been revised in a number of areas, including the equality of legal representation and an extension of the timeframes for completion and submission of paperwork. Other revisions include preserving the role of the Ombudsman in cases which have been investigated by his office and expanding supervision for witnesses. With regards to stakeholder engagement, the regulations were the subject of a formal targeted consultation lasting 12 weeks, which concluded in October of 2013. And following this extensive engagement took place with those stakeholders to cement views following a number of personnel changes. Thereafter, a further formal targeted consultation ran for 12 weeks, concluding in November of last year. Unsurprisingly, not all stakeholders agree on all the provisions. However, all are supportive of the introduction of the reforms and support the policy intent. Work is ongoing in respect to the final legislative amendments, and it is anticipated that the 3 sets of regulations will come into operation in October of this year. Final drafts are scheduled to be available in July. Officials recognise this has taken some time to reach this stage since the first draft regulations were provided to the committee, and during the intervening period there has been ongoing engagement with policing stakeholders with a view to ensuring that the new procedures are fit for purpose. In implementing any change to the legislative framework for PSNI discipline and unsatisfactory performance procedures, it has been important for us to recognise that Northern Ireland operates within a unique environment and context with different complaint mechanisms. Guidance to support the new regulations is clearly important to those who both operate and come into contact with the procedures. Whilst this already exists, it required considerable revision to reflect the changes. Work is ongoing in this respect, and the draft will be shared with stakeholders for comment, noting that it will not replicate the already prescriptive legislation. In concluding, significant work has been carried out in the development of the new arrangements in Northern Ireland. Undoubtedly, the transition to these arrangements will require effective management with robust strategies in place to facilitate training, and the PSNI are already well advanced in this planning. The Department is now seeking to introduce regulations to streamline the procedures and mechanisms, moving towards procedures for police officers that more closely reflect those which operate in normal employment practice. The proposals will modernise the system and shift the emphasis towards development and improvement. This is a significant opportunity to streamline the current bureaucratic processes and for our police service to realise the operational benefits it will bring. I hope this is helpful to the committee as it considers the SL1, and will be happy to take any questions.
Okay, thank you very much. You mentioned about how virtually everybody is supportive of the direction of travel, but some of the detail there's difficulty with. Where are the Police Federation on this, or have they given any sort of response?
Yeah, there was disappointment on the part of the Police Federation, in particular, really on one issue, and that was in respect of the transitional arrangements for the regulations. After careful consideration, the department has decided that the date that the alleged offence is reported to the authority will dictate the applicable regulations. So that does mean that the new regulations will be applicable, effective for everything notified, effective from the 1st of October. They would have preferred that it was the date of the incident that dictated the applicable regulations. But in practical terms, it just was not going to be easy to work with in terms of managing multiple sets of regulations, particularly in cases where you do have alleged issues of misconduct that have perhaps spanned a number of months or years. As I say, they were disappointed with that outcome, but I believe are acceptant of it.
And in terms of any other issues that people have raised, or what other issues have people raised and who have raised them?
Certainly there was a keenness to ensure that the role of the Ombudsman's Office was preserved and not reduced or dissolved in any way, and that has indeed is one of the outcomes in terms of the draft regulations that there are. Over and above that, anything particularly raised through the consultation process and the engagement. There was a little in terms of just the procedures and how they would work at a very granular and detailed level, but usefully some of the stakeholder engagement sessions we held on a multiple party basis allowed us to work those issues through.
There was a query just on the guidance, and we are working with stakeholders with regard to that to ensure that the guidance is obviously from a consistency viewpoint, meets all stakeholders' expectations.
And just finally, the PSNI have indicated there'll be upfront costs in terms of additional training and things, but as you've mentioned earlier about the cost to the police service of officers on suspension, and I remember from my time in the policing board, the amount of money that was spent on paying officers who are on gardening leave. Have we any sort of ballpark figures about how much we think it will cost the PSA in the short term, and if there's any estimation of how much they reckon they could save in the longer term?
The costs are deemed to be notional, in that really it's very much around preparing material, putting it on the internet, and certainly they're planning to introduce some e-learning, which is supported by close control really and monitoring of the new arrangements when they do come into play. Whilst the PSNI, in terms of the benefits, the PSNI hasn't got hard costs in terms of the cost of suspended officers who are obviously on full pay, but certainly in terms of days lost, it is a figure that's on the decline, but the total days lost in 13-14 was just over 8,000. So it's clearly something that there is an opportunity to influence further down.
Thank you. Stuart.
Thank you, Chair. Public confidence in the PSNI is paramount to everything that the PSNI does. To what extent will this enhance, or indeed does it engage at all, in public confidence, and how much has that been taken into consideration in redesigning these processes?
I think one of the things that will be particularly helpful for the public, as well as to the peer group within the force, is to see that matters of misconduct and performance will be dealt with much more expediently, and therefore that time taken to conclude cases will I think will make a great difference to to both communities, I think.
Okay, Raymond.
Just a sort of, in terms of the type of inquiries that are carried out, are these all internal matters? These aren't as a result of complaints from members of the public. It would be internal to the workings of the PSNI?
There would be a combination in terms of internal issues, criminal proceedings, or indeed matters that were perhaps referred by the Ombudsman's Office in terms of recommendations that would be taken into consideration by the force in these procedures.
So in terms of that category, unsatisfactory, what sort of thing would that be?
Unsatisfactory performance. What you would find within that category would be really the minor discipline.
Performance really is failure to investigate, and then you have the areas then of conduct and gross conduct. Misconduct examples include inappropriate text messages, giving inaccurate accounts to supervisors. Gross misconduct could be any act of dishonesty, theft, falsifying records, etc.
So they're nearly, they are in the main internal to the case. In terms of the sanctions, what sanctions will now be in place if there's no longer financial penalty or reduction in pay? What would the sanctions then entail?
There will continue to be a range of sanctions available in terms of and those which would be akin in normal employment practice, but as well as that there will be a sanction which can be imposed in terms of redeployment to another post within the service, which I suppose isn't necessarily quite so typical.
And what was the rationale for removing financial penalties and reduction in pay?
There was a view that financial penalties did not necessarily support the learning and development of these officers, and the other factors that did come into play in that is that obviously this could place those penalties could also place officers and their families into a very difficult financial position, as well as the fact that generally in employment practice it is not something that would be introduced as a sanction.
And in terms of going for the balance of probabilities rather than beyond reasonable doubt, how does that decision be taken?
That is consistent with the forces in England and Wales, and in fact I think it is the case across the rest of UK.
Scotland and Republic of Ireland as well.
Notwithstanding that, but I mean, does that, that gives the person who's defending themselves no less probability, or unreasonable doubt? Is there a particular reason why it's that?
In terms of being able to directly answer that question, no. But I think certainly there is a very strong and robust evidence base that's required in terms of whenever the police is considering these cases, and therefore I think whilst it is in the balance of probabilities, it is still a very robust assessment of the evidence that's actually at hand.
Okay, thank you.
Okay, anyone else? No. Okay, thank you very much.
Thank you very much.
Okay, members. Just ask if members are content then with the proposals. Yeah. Okay. Can move everyone on to agenda item 7. Refer members to page 541 through to 881 of the meeting folder. The Minister has provided a final draft of the Mental Capacity Bill, Explanatory and Financial Memorandum. The draft bill is being considered by the Executive, with both Health and Justice Ministers hoping that the bill will be approved to allow for the introduction of it in May 2015. The Justice Committee and Health Committee previously agreed that a joint ad hoc committee made up of members from both committees should be established to consider the results of the consultation and undertake the committee stage of the Mental Capacity Bill. So if members are in agreement, I'll now write to the Business Committee and ask it to establish a joint ad hoc committee in accordance with Standing Order 64C. Agreement? Then item 8 then, if you refer members to page 883 of your meeting folders. You'll recall at the meeting on the 10th of December, the committee agreed that it was content with the proposals by the Department for regulations to establish a career average revalued earnings pension scheme for members of the devolved judiciary and specify the judicial office holders to whom the regulations would apply. At the meeting on the 4th of February 2015, the committee considered and approved the statutory rule to establish the pension scheme for members of the devolved judiciary. The statutory rule specifying the judicial office holders to whom the judicial pension regulations will apply was laid on the 18th of March 2015 and came into operation on the 1st of April. The statutory rule is subject to the negative resolution procedure, and there have been no changes to the policy content since the SL1 was submitted to the committee. The Assembly Examiner for Statutory Rules has highlighted that the statutory rule was laid in breach of the 21-day rule. The Department has advised this occurred as a result of administrative oversight, which the Examiner has accepted as reasonable. So if members are content, I'll put the formal question that the Committee for Justice considered Statutory Rule number 2015/161, the Public Services Pension Act Northern Ireland 2014, Judicial Offices Order Northern Ireland 2015, and has no objection to the rule. Agreed?
Agreed.
Okay. Agenda item 9 then, I refer members to page 892 of your meeting folder. the Department is proposing to make a statutory rule under powers conferred by the Health and Safety at Work Northern Ireland Order 1978. It's being made to comply with EU Regulation number 1272/2008 on the classification, labelling and packaging of substances and mixtures, the CLP regulation, and will provide for the appointment of competent authorities and enforcement in Northern Ireland in relation to explosive substances and mixtures. The Department has highlighted that if necessary legislation is not made by the 1st of June 2015, the European Commission will begin infraction proceedings. The rule, which is subject to the negative resolution procedure, will therefore apply from the 31st of May of this year. A targeted 6-week consultation was carried out with organisations and individuals who deal with explosives in Northern Ireland, and no responses were received, which the Department advises respects the general and controversial nature of the proposals. So can I ask members, are they content with the proposed statutory rule, or does anybody wish any further information? Happy enough? Okay, agenda item 10 can refer members to page 911 through to 944 of the meeting folder. Following the oral briefing on the 28th of January on the Department of Justice budget position, the Minister has now provided the final consolidated Department Savings Delivery Plan, which sets out the key risks and overall impact on service delivery for the Department, agencies and non-departmental public bodies. The Minister has also outlined that an allocation of £53.3 million funding was provided for Desert Creek Community Safety Training College capital project in 2015-16. However, this was dependent on agreeing the drawdown of unspent funds from Treasury in 2015-16. He's indicated that negotiations with the Department of Finance and Personnel and Treasury are continuing, and he will update the committee when further information is available from the Department of Finance and Personnel. So are we happy enough with that, or does anybody require any further information?
It might be useful if the Department of Justice were asked for an update on the detail of those negotiations on the program, because we're getting the same answer for about 6 months now.
Yeah. We've got a briefing next week on this. So
right, okay.
An opportunity. Okay.
Thank you.
Enough. Then item 11 then, can I refer members to page 946 of your meeting folder. One of the Department of Justice commitments arising from the PFG is to develop an action and assistance strategy for offenders to cover custodial and non-custodial settings by March 2015. The Department has now provided a draft assistance strategy and action plan entitled Supporting Change, a strategic approach to assistance, which has been developed by a working group comprising senior representation from the Department and key agencies and NDBs and voluntary organisations. The draft strategy outlines the Department's strategic approach and commitment to assistance, sets out an agreed understanding of the assistance across statutory and non-statutory organisations, and provides an initial action plan outlining how change will be delivered by embedding the assistance principles in policy and practice across the Northern Ireland criminal justice system. It includes 4 key objectives and provides details of actions that will be undertaken to support the approach and the governance arrangements for monitoring the action plan and reporting in progress to reduce reoffending and improve outcomes for individuals who have offended. The action plan will be subject to review by the Criminal Justice Inspection Northern Ireland and revised in light of progress made. Again, can I ask members to be content with the strategy and action plan, or does anybody require any further information? Chris?
Just think there's a number of issues around it. I certainly would like further clarity, maybe from officials, maybe the next time they're in, around some of these issues here in this paper.
Okay, we'll request an oral briefing then and factor that in, if that's okay. Agenda item 12 then, can I refer members to page 977 of your packs? Do you recall that in January 2013, the committee considered and agreed 8 action plans brought forward by the Department to deliver the various strands of the Community Safety Strategy, which was launched by the Minister of Justice in July 2012. The Department has also undertook to provide a written report on progress to deliver the action plans on an annual basis to the committee. The first progress report was noted by the committee in February 2014, and the Department has now provided the second progress report for consideration. The report provides the latest statistical and performance information for each of the strands and details the actions that have been delivered. The departmental briefing paper also sets out details of the investment and programme funding during 14-15 and delivery mechanisms used, including the contribution of the policing and community safety partnerships. The current action plan ran until the end of March 15. Therefore, the Department has provided new action plans for 15-17 to cover the final 2 years of the Community Safety Strategy for each of the strands, apart from the one covering domestic and sexual violence, which is not yet available due to the delay in finalising the Stopping Domestic and Sexual Violence and Abuse Strategy. So again, can I ask members the content to note the progress on those reports?
Agreed.
Okay. Moving on then to agenda item 13, which is correspondence. There are 14 items of correspondence at pages 1066 to 1118 in the meeting folder, and one item in your tabled papers. If I can just mention a few of them. Item 1 at page 1066 is correspondence from the Minister regarding the future of the Northern Ireland Law Commission. The Minister still intends to remove funding from the Law Commission due to the significant financial pressures facing the department. He has, however, decided not to repeal the provisions in the Justice Northern Ireland Act 2002 establishing the Law Commission, and with the agreement of the Lord Chief Justice will appoint a new chair of the Commission. This will ensure that the Law Commission will continue to exist statutorily and will, when required, be in a position to contribute to UK-wide law reform projects. The Minister also hopes that the Commission can be re-established when funds become available, and his decision not to repeal the founding legislation would make this objective much more straightforward. Again, if members wish to note that, unless there's any comments.
Yeah, well, I just want to say, I mean, it represents some degree of retention. I think, however, the Commission will be virtual rather than real, but at least it's been mothballed statutorily, and that, I suppose, is to be welcomed. But it is regrettable that the Commission itself is not going to function properly over the next short while, anyway.
Item 2 then, page 1068 of your folders, is correspondence from the Minister relating to proposals for the reconstitution of the Policing Board. The Minister has clarified how decisions regarding who will be appointed for a 3-year period and who will be appointed for a 4-year period will be made. It has indicated that the 9 independent members will be appointed on the basis of merit, and he will seek to ensure a balance of skills, knowledge and experience as far as practicable. It is his intention that those members who are successful in applying for a second term will in principle be considered for the 4-year terms, with new members being considered for the shorter 3-year term. In his view, this will maximise continuity. So again, this is for members to note unless there's any specific issues to raise. Okay, item 3 at page 1071, correspondence from the Department in relation to consultation and changes to the cost protection scheme for Irish Convention cases. The Department has indicated that it intends to wait until proposals for changes to the Irish Convention cost protection scheme in England and Wales are clearer before proceeding with a similar consultation exercise in Northern Ireland. The Department has outlined its rationale for the decision and advised the Committee will be provided with an opportunity to consider the relevant draft consultation document before it's published. The Department also welcomes any comments from the Committee to delay consultation. So again, it's really to note unless anybody has any specific comments to make. Okay. Item 4, page 1076, correspondence from the Department providing update on funding for voluntary search and rescue organisations operating in Northern Ireland. The Department has indicated that 46,000 has been transferred from the Department of Culture, Arts and Leisure from the 1st of April 2015, and it's identified an additional £50,000 from its budget. The response also outlines the application process for funding and the funding allocations that have been approved by the Minister. Again, that's just a note.
Can I come in there, Chair? Yeah, can I first of all welcome the funding, both the 46,000 and then the additional 50,000, bringing a total of 96,000 available. And that brings me to my point. The total amount recommended for allocation is 74k. So I'm wondering where, because obviously some of these organisations have applied for much more. There's the North West Mountain Rescue Team applied for 55k. Amount recommended is 25k, so just under 50%, as is the same with the Irish Cave Rescue Association and others who aren't getting the full amount that they had applied for, and they're getting less than 50% funding. So that may well be a critical point for some of these. And whilst there's 96,000 in the pot seemingly, and they've only allocated 74, I'm wondering why the shortfall and why that can't be added to.
I think there's a contingency fund there that allows for additional funding if there's additional travel costs or something like that.
Right, okay, and that would be like a slush fund for that then to dip into?
Yeah.
Oh, okay, thank you.
Okay. Item 9 at page 1089 is correspondence from the Department providing a copy of the Justice Departmental Action Plan in response to the recommendations contained within the Marshall Report of the Inquiry into Child Sexual Exploitation in Northern Ireland. The action plan has been developed by the newly constituted Marshall Delivery Group and sets out the actions, outcomes and associated timings against each recommendation. The Minister for Health has established a senior officials group from the Departments of Justice, Health and Education to ensure there remains a coordinated cross-departmental response and provide regular and simultaneous reporting of progress to ministers. Just to remind members that following the oral briefing on the 4th of February 2015, the committee agreed that once the action plan was available, I'll discuss with the Chair of the Health Committee whether it would be a benefit in scrutinising application on a joint committee basis. So if members are happy enough, I shall seek a meeting and come back to members on that issue. Item 10, page 1099, is correspondence from the Chair of the Procedures Committee, seeking the Committee's views on the pilot project to test a procedure for the management of draft affirmative statutory rules laid by the Attorney-General, and while the process should be refined by omitting the establishment of an ad hoc committee. So, effectively, I'm asking members of their views on this. You'll recall the issue came before that we scrutinised the rule, but then there had to be an ad hoc committee to move it on behalf of the Attorney-General. My understanding is that the committee had previously discussed this issue in April 2014. At that stage had agreed that it wouldn't be within the remit of this committee to speak on behalf of the Attorney-General in debates on the floor of the House. My personal view, that would still be my view, and that although imperfect, I think the ad hoc committee being established for these sorts of things is probably the best vehicle in which to advance it. I think there is some surprise that they didn't perhaps ask the Justice Committee for the papers for the discussion that we had. Nevertheless, I think for more contentious issues they would want to do that. But are members generally happy with how we approached it before with the ad hoc committee, or are there any other views? Generally happy enough?
Happy.
Okay. Any other pieces of correspondence that members wish to draw to the attention of the committee?
Just one from Amnesty International seeking to make a presentation.
Yep. I'm going to come down under Chair's business.
Oh, sorry, yeah.
That's okay, yeah.
Right,
Which is moving swiftly on the Chairman's business right now. Item 1 is that letter which Mr McGuinness referred to, page 1120. Amnesty International have requested an opportunity to present the key findings and recommendations of its report on Northern Ireland barriers to accessing abortion services, which was launched on the 26th of February. So, again, I ask members whether they wish to facilitate a briefing on that issue in the forward work programme.
Well, Chair, I was just going to say, I mean, I see no problem with them briefing us. I mean, it's they have been active in this whole debate, and I think it might be worthwhile just to hear what they say in particular. And I would suggest that maybe we do have. Yeah.
Sure. Okay. Everyone happy enough? Okay. Item 2 is an invitation from the Ulster University to discuss the contribution of the University to the justice sector. Refer members to page 1121 of the meeting folder. Professor Paul Carmichael from the University has written, inviting the committee to visit the Jordanstown campus to discuss the contribution of the University that it makes to the justice sector, meet with some of the students and discuss potential opportunities for working together. Great part of the world, so if members are happy enough, we will facilitate perhaps a meeting at some point in the future there. Happy enough?
Yes.
Okay. Agenda item 15 then, is any other business? Have members any other business to raise? If not, just remind members the next meeting. Sorry.
Yeah,
I'm sorry.
A couple of things. First of all, it would appear that the name of HNP Hyde Bank has been changed.
Yes.
And changed without any reference or consultation with this committee. And perhaps we would raise that matter with the department as to what is going on there. And I know they're suggesting it's in line with the recommendation of the oversight review panel. It is now a Hyde Bank College. Most instances in college have to have some sort of a qualification to get into college.
Oh, coming out.
And in this instance, the qualification is that you've had to have committed a crime and been found guilty of that and been sent there. So it's all very fluffy and nice, all of that there. But it strikes me that it is moving away from what the purpose is, and that is it is corrective in the first instance. And it is somewhere that people are put there not to go for their studies, because that's available to them outside of that location, it is somewhere that people are put because they have committed crimes, and that shouldn't be lessened or seek to be demeaned from. That was the first issue. The second issue is that in the last month or so, certainly sometimes since the committee was sitting because of Easter, the case of Mr. Bryson was heard, and he was found to be guilty, and I think that we should have some concern about that particular case, that the burden of proof was to demonstrate your innocence. McGuinness, for example, has spent considerable years at the bar defending people's innocence on the basis that they had to be found guilty. And I know that there are certain areas of law that and they're quite restricted, where that has been allowed in the past, where you had to demonstrate that you weren't guilty. I would be somewhat cautious as to that being extended widely, and particularly in the fields that they may now be entering into. And I'm not sure what we do, but I raise the point because I think it's something that, irrespective of the individual that was involved, it is a significant step for justice, and it may be something that we'll want to reflect on in some way.
Yeah, no, on the first issue, it's a curious name for the college. It does make it sound like any other FE college in Northern Ireland. I'm not sure that's something which is particularly welcome, I must say. So let's write to the department, find out the rationale for that and whether and why we weren't consulted on that. On the second issue, I mean, members will appreciate we can't get involved in individual cases, but I think that the wider point of if this is some sort of direction that the justice, let's try to find out more information about that, and we can come back to that. I'm certainly happy to do that. If
I'd appreciate
it. Could I say, Chair, just in relation to the first point, my understanding is that the concept of a secure college comes from the United States of America, where they have a whole series of colleges, in effect penitentiaries for young people, and it's really a term of art rather than an academic definition, and I think that might be the notion behind this as well, but certainly, I mean, we can explore it, but I think the basic concept of trying to educate and train offenders, young offenders in particular, is a good one, which I think all of us are supportive of, irrespective of the title of the institution.
I think that's probably fair.
It's prison.
It's usually a college where people learn more about crime.
Correctional college.
And if they were actually doing the correctional thing, and sadly, the vast majority of young people who go to young offender centres will end up in prison, latterly. And, that needs to be the purpose. Some fluffy aim is not going to change the outcomes. And that's what we're looking. We're looking people to move away from crime. Unfortunately, that's not the case.
Very sure.
I think, Chair, will find that it's not a fluffy new name, but it is part of a complete concept in terms of how young people who are offenders are dealt with by this society. And the whole purpose is to turn them away from crime and to ensure that when they do leave that facility, they will have had a correctional opportunity in respect of education and training, educational activities that are not criminally directed, but rather are community directed. And I value that. And if it assists one young person in terms of how they describe where they have been to a prospective employer, and it gets them and gains them employment, then I think that has been well served.
Can I thank members for the segue, moving seamlessly on here to the fact that the next time we meet will be for the Justice Seminar, which is the first Justice Seminar. Lord Chief Justice will be talking about innovation within the youth justice system. So again, thanks, Stuart, for that seamless link. And members, can I just before we finish up, members, just remind you that people have been emailed about the informal lunch beforehand with Lord Chief. Please do respond as quickly as you can so we can make arrangements for that. And please do try your best to come along to the Justice Seminar.
What time's the lunch at?
The lunch will be 12:30, isn't that right?
12:30,
yeah. Justice Seminar starts 1:30 and the committee will be at 3 o'clock. Okay, thanks very much, members.